You're listening to an Airwave Media Podcast.
Hello, and thank you for joining the American Revolution. Last week we covered the elections of 1792, which gave us the senators and representatives for the Third Congress, and also the re-election of George Washington. The new Congress could have begun its session in March of 1793. In fact, the new Congress did not meet until December of that year. Following the December 1792 elections, the Second Congress continued to meet and pass legislation until March. In February, it took up the Fugitive Slave Act. Before we get into the substance, I need to make clear that the law was not called the Fugitive Slave Act. That's what everyone called it later. In fact, the text of the statute does not even use the word slave. The statute was entitled, quote, "An act respecting fugitives from justice and persons escaping the service of their masters." The first part of the law dealt with returning fugitives who were facing criminal charges. The second part referred to, quote, "a person held to labor in any of the United States or territories." This included both slaves and indentured servants. The Constitution had already explicitly authorized this power. The Constitutional Convention had added a clause, quote, "No person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due." In other words, if a person was a slave or under an indenture in one state and they escaped to another state where they were free, that state would still be obligated to return them to the state where they were being held to slavery or indentured servitude. The Constitution did not explain all the details, like how the process would work, what proof would be required to take the accused into slavery, or who would pay for all of this. The incident that brought this really to the attention of federal officials actually predated the ratification of the Constitution. In 1780, Pennsylvania had passed its Gradual Abolition Act, something we discussed back in episode 241. The law permitted slave owners to retain any slaves that they owned prior to the law's passage. To comply with the law, though, owners had to register their slaves with the state and pay a $2 fee. The point of registration was to show exactly who was a slave at the time that the law changed. Children of slaves born after that point would be free, and they didn't want slave owners claiming that this person was born before the passage of this statute. It was also illegal to bring new slaves from outside the state into the state and become slaves, so registration would be evidence that the slave lived in Pennsylvania as a slave prior to the passage of the legislation. Any slave who was brought into Pennsylvania after the law's passage and remained there for at least 6 months was automatically emancipated under the law. A Maryland slave owner named Davis moved to the northern tip of Virginia, in what is today the northern panhandle of West Virginia, that area up near Pittsburgh. The border between Virginia and Pennsylvania was unclear at the time, and it was eventually determined that Davis's farm was over the line and he was living in Pennsylvania. Because of this confusion, Pennsylvania extended the deadline for registering slaves for people in that area who had thought they were living in Virginia. Despite this extension, Davis still failed to register his slaves and continued to keep his slaves working on his farm in Pennsylvania. Under Pennsylvania law, they were free. But I guess no one told the slaves that at the time. It didn't become an issue until 1788. It's not clear what happened at that time, but there was a local chapter of the Pennsylvania Abolition Society that was becoming active in the area. So Davis might have become concerned that his enslavement of other people was illegal at this point. He took his slave John back over the line a few miles to the west into Virginia and rented him to a neighboring farm. Several of John's neighbors were upset by this. They went into Virginia, found John, and brought him back to Pennsylvania, where he was already a free man under Pennsylvania law. The Virginia farmer who had rented John then hired 3 Virginians to cross back into Pennsylvania and bring John back to his farm as a slave. He then moved John to another part of the state where it would not be easy for the Pennsylvanians to get him back. For Pennsylvania, this was a case of kidnapping. John had lived in Pennsylvania for years and under state law was a free man. Officials indicted the three Virginias on charges of kidnapping. Governor Mifflin of Pennsylvania sent a request to Virginia to extradite the accused men for trial. The Abolitionist Society also hired an attorney to have John returned to freedom in Pennsylvania. Virginia refused to act on any of the extradition requests. The three alleged kidnappers remained free in Virginia. John remained enslaved in the eastern part of the state. 3 years after the kidnapping, nothing had changed. Virginia refused to turn over anyone, while the case of a free black man who had been kidnapped and enslaved in Virginia was drawing more attention in Pennsylvania. Virginia's Attorney General refused to take any action, writing that the kidnapping of a free black man was not a felony in Virginia and would not be considered for extradition. The kidnappers had not violated Virginia law, nor had they violated federal law. Therefore, Virginia had no authority to arrest them or extradite them. Both Pennsylvania and Virginia sent their legal arguments to President Washington, who turned them over to his Attorney General, Edmund Randolph. The Attorney General found issues with the claims of both states. The Pennsylvania faults were mostly technical, not providing an authenticated copy of the law that had been broken. Randolph also rejected Virginia's claim that it could not arrest anyone who had broken a law in another state, even if the act would have been legal in Virginia. Randolph recommended to Washington that he tell the Pennsylvania governor to correct the technical errors with their extradition request and then resubmit their claim to Virginia. Virginia, however, still refused to turn over the kidnappers. Local Virginians in the area accused the Pennsylvania Abolition Society of stealing other slaves and carrying them to freedom in Pennsylvania. This case was becoming a politically charged issue in both states. In the fall of 1791, Washington sent the whole mess to Congress with a request that they come up with some laws that would cover the extradition of accused criminals, as well as the return of fugitive slaves. Now, by this time, all of New England, as well as Pennsylvania, had either abolished slavery or passed a law that would gradually abolish it over time. Among northern states, only New York and New Jersey had not passed any abolition laws. While there was a growing abolition movement in many states, the overall consensus still favored former slave ownership and the return of escaped slaves. Still, Congress had to come up with an acceptable law that detailed how extraditions would be handled. Congress did what they always did, form a committee to study the matter. The committee consisted of 2 members from Massachusetts, one of whom was Theodore Sedgwick, who you may recall years earlier had litigated the cases that ended slavery in Massachusetts. Also on the committee was Virginia slave owner Alexander White. The committee came up with a process for the return of either accused criminals or suspected runaway slaves. Someone would have to file a valid application for an arrest warrant to the governor of the state. The governor would then issue warrants to law enforcement to have them arrest the fugitive. If arrested, the accused would be turned over to the purported owner of the slave or to state authorities in the case of somebody who was being prosecuted criminally. There was no right of due process for the accused before extradition, and those making the claim that a person was enslaved did not even have to submit their claim under oath. The bill also imposed heavy fines for anyone who interfered with the return of a slave or for officials who refused to act on valid warrants. The House ended up never considering the committee recommendation, and instead they decided to wait for the Senate to propose their own bill. Congress adjourned for the year and returned in March of 1792. The Senate did appoint its own committee, but that committee never reported back before the session ended in May. The Senate reappointed a committee in November after it returned again. By this time, it was more than a year since Congress began considering the matter. The first Senate bill, offered on December 20th, 1792, was even more in favor of the slave owners. It required all citizens to participate in the capture of fugitives and imposed fines and jail time for anyone who simply refused to help. It permitted the return of slaves based on the deposition of just one credible person without even requiring it be under oath. It also proposed a daily fine for anyone who harbored or concealed a fugitive. That fine would be paid to the slave owner. Senators threw out that bill and began consideration of a second bill. This second one did not require people in a free state to participate in the capture of an alleged fugitive. slave owners or their agents were free to seize someone themselves. They didn't even have to obtain a warrant. However, they would be required to bring that captured person before a judge or magistrate before trying to leave the state, and to prove to the satisfaction of the judge that this person was still bound to service. This would require sworn testimony or affidavits. The bill also proposed a statute of limitations. If a black person had lived in a free state as a free person for a certain number of years, they didn't quite get to what that number would be, then removal would not be permitted. Of course, senators from slave states were unhappy with this bill after more than a week of debate. So they submitted a third bill for consideration. This bill removed that statute of limitations restriction. While it did not require locals to help capture the alleged fugitive, it did restore fines for anyone who actively obstructed or hindered the capture. It allowed slave owners to sue for damages in federal courts for anyone who tried to prevent the capture of their slaves. In addition to civil damages, those who hindered a capture could be fined $500. Local law enforcement could not be forced to help capture slaves, but it gave private slave catchers a pretty free hand in capturing anyone they wanted without any hindrance. The Senate passed the bill and sent it to the House, which made a few minor technical changes. Both the House and Senate approved the bill overwhelmingly, and after both houses passed the final bill, it went to President Washington, who signed it into law on February 12, 1793. As for the incident that started this whole matter, none of the kidnappers from Virginia were ever extradited for trial, and John remained a slave for the rest of his life in Virginia. With the Fugitive Slave Act complete, Congress turned to some other business. One bill they took up just days after completing the Fugitive Slave Act was an amendment to the patent process. Under the law passed in 1790, Thomas Jefferson, as Secretary of State, had to make a determination about whether a patent application was sufficiently important or useful to justify receiving a patent. Jefferson hated this work. He didn't have enough time to evaluate each application properly, and he felt he was essentially forced to make a decision without really knowing enough to make an informed decision. Jefferson wanted the process to be changed so that he would not have to spend so much time evaluating each application. The new Patent Act, which was signed into law on February 21st, granted patents pretty much automatically. It became a clerical function that really didn't require much research or deliberation. If someone wanted to challenge a patent, they could take it to court, and then a judge would make that evaluation. Another issue before Congress was the fact that the states, and even private individuals, were buying up Indian land to open up more land for settlers. Congress approved a new law requiring that no sale of lands would be valid unless it was conducted through a public treaty by the federal government. Since land sales made under questionable authority could lead to more war with the Indians, and they still hadn't resolved that problem in the Northwest Territories, Congress really wanted more control over this process. They passed the bill, and President Washington signed it into law on March 1st. Congress also took up some amendments to the Judiciary Act. I mentioned last week that Chief Justice John Jay was considering quitting because of the miserable experience of having to ride around the country on circuit to hear appeals. Jay and other justices petitioned both President Washington and members of Congress to eliminate what one justice called, quote, exile from our families for half of each year. In January 1793, Justice Thomas Johnson resigned, citing the hardship of having to ride circuit for half a year. At the end of 1792, Washington gave another State of the Union address calling for judicial reform. What justices wanted was more judges who would hear cases. They wanted appellate judges who would hear appeals. Then the Supreme Court could be a secondary appeal, and they wouldn't have to ride all over the country to do it. Under the current system, circuit justices would hear appeals, then they'd rule on them at that time, but then if the case got appealed to the Supreme Court, they would all have to get together and rule on the exact same case again. Having the same person rule on the same case twice was something that many justices considered unconstitutional. Congress considered the idea of adding appellate judges, and they rejected it. Members of Congress thought that circuit riding was important so that the justices were forced to have more of a connection to the localities across the country. They also didn't want to pay for a whole new level of judges. Instead, they reduced the circuit riding a little by no longer requiring that a 3-justice panel hear each case on the circuit. Rather, 1 justice could hear cases. This way the work was a little more spread out. Congress did take one thing off their plate. Justices were also expected to review and rule on the pension claims for Revolutionary War veterans. They had to evaluate whether a veteran was destitute and disabled enough to qualify for a pension. A fight over this took place in 1792, when a circuit court held that the Pension Act was unconstitutional and refused to consider any applications. Attorney General Randolph argued this point to the Supreme Court, but the court then had a problem because half of the justices decided that an attorney general could not seek a writ of mandamus unless the president explicitly authorized him to do so. Randolph got around that problem by leaving the court and coming back a few hours later saying that he was not appearing as the attorney general. Instead, he had gotten permission to appear as the personal attorney for one of the pension applicants. The court refused to rule on the case and held it over for the next session. Before that next session met, Congress acted. The new law moved responsibility for pension applications from the circuit courts to the federal district courts. It also authorized the appointment of several commissioners to assist with the process of evaluating pension applications. The bill put some limits on federal courts, including preventing them from issuing injunctions to state court activities. Both the House and Senate passed these bills, which President Washington signed into law on March 2nd. That was the last day of the Second Congress. They concluded their business and adjourned. The new Congress could have started the next day, but instead it would not meet for another 9 months. President Washington's second term, however, began immediately. The president took the oath of office to begin his second term on March 4th. Unlike his first inauguration, which included ceremony and public celebration and a parade, the second inaugural was a low-key affair. Washington rode in a coach to Congress Hall. At noon in the Senate chamber, Associate Justice William Cushing issued the oath of office, as Vice President Adams, Thomas Jefferson, and members of the House and Senate watched. Washington then gave the shortest inaugural speech in history. It's so short that I'm going to read it in full here. Quote, "Fellow citizens, I am again called upon by the voice of my country to execute the functions of its chief magistrate. When the occasion proper for it shall arrive, I shall endeavor to express the high sense I entertain of this distinguished honor and of the confidence which has been reposed in me by the people of America. Previous to the execution of any official act of the President, the Constitution requires an oath of office. This oath I am now about to take in your presence, that if it shall be found during my administration of the government I have in any instance violated willingly or knowingly the injunction thereof, I may, besides incurring constitutional punishment, be subject to the upbraidings of all who are now witness of this present solemn ceremony." That was it. After that, Washington got up and left the building. A small crowd had gathered with the president. He got 3 cheers as he climbed back into his carriage, and he was home by 1 p.m. With that, Washington began his second term as president. Now, next week, we're going to discuss the first crisis of Washington's second term, and that is the Citizen Genet affair. Hey, thanks for joining the American Revolution Podcast After Show, part of the Airwave Media Network. Thanks to my Patreon supporters in the Alexander Hamilton Club, George Davis, Michael Mulhern, Mitchell Anderson, and Gordon Kemp. Thanks also to Robert Morris Circle supporters, Keith Mello and Patrick LeBeau. I also want to thank Frank Lipsky and Gregory Austin, who joined as standard bearers this week, and also to Emily Gibson, who sent a one-time gift via PayPal. I also want to shout out to Devin, who recently began support at the Privy Council level on Subscribestar. I do take subscription on Subscribestar as an alternative to Patreon, since some people don't like Patreon. I really appreciate everyone who helps to keep this podcast going, either through an ongoing financial subscription or through one-time gifts via PayPal or Venmo. This week we covered the final legislation of the Second Congress and the beginning of Washington's second term. The big issue this week was, of course, the Fugitive Slave Act. As I mentioned in the main episode, it wasn't called that. But in this law, we see the beginning stirrings of abolitionists and slave owners beginning to clash over this issue. The dispute over the slave, who we only know as John, and is, I guess, known by his master's name, Davis, became the main reason that Congress finally addressed this issue. The act passed by Congress dealt with the issue of both fugitives from justice as well as fugitive slaves, both of which were a matter of contention in the Davis affair. Abolition was a growing movement at this time. The words that had inspired independence were being taken to heart by a new generation, which was pushing against an institution that seemed to violate a nation that was based on the protection of life, liberty, and the pursuit of happiness. In fact, abolition movements were spreading all over the world. Britain had a strong and growing movement at this time. It had also become a core value of the French Revolution, although both Britain and France still kind of turned a blind eye to slavery in their colonies. But even in the colonies, there was change happening. The same year that the U.S. passed the Fugitive Slave Act, Upper Canada outlawed the importation of slaves and put into place a gradual emancipation of slaves there. At the time, Pennsylvania was completely surrounded by slave states. Virginia, Maryland, Delaware, New Jersey, and New York all still had legalized slavery and no plans in place to abolish it, even gradually. Of course, Pennsylvania itself still had slaves at this point, but it had passed its Gradual Abolition Act in 1780. By the time of the 1790 census, Pennsylvania still had about 3,700 slaves, about one-third of the total black population in the state. Over time, the free black population increased while the number of slaves dwindled. The only slaves recognized by law had to have been born by 1780. There were less than 1,000 slaves in Pennsylvania by 1810, with the number finally reaching zero by 1847. Now, as I said, the abolition movement grew much more powerful in Pennsylvania over time. The Quakers had been among the first groups to take a strong moral stand against slavery, but that view grew within the larger population in Pennsylvania over time. Pennsylvania, along with Massachusetts, was probably one of the two major centers of abolition in the period leading up to the Civil War. In 1793, though, abolitionist numbers were smaller. More importantly, most of the federal power was in the hands of slave owners. Washington, Jefferson, Madison, Attorney General Randolph, and others were all Virginia plantation owners, and they all owned a large number of slaves. While many of them had begun to confess their personal concerns over slavery, they were absolutely not about to end the institution in anything other than a gradual process. These slave owners were also not about to accept slaves taking freedom into their own hands and escaping as fugitives. The story of Ona Judge provides an interesting insight into Washington's views. Ona was a young woman who served Martha Washington. She was only 15 years old when she accompanied the family to New York after Washington's election as president. She learned about freedom during her time there and in Philadelphia while tending to the First Lady. At the end of Washington's second term as president, she ran away rather than being returned to Mount Vernon. President Washington was outraged by what he regarded as a betrayal. He told friends at the time that they had always treated Ona very well, even giving her cash to go see plays or go to the circus while they were living in Philadelphia. When she ran away, he pulled out all the stops to track her down and bring her back. He continued to pursue her for years, even making a final effort just months before his death in 1799. Despite his efforts, Ona built a new life for herself in New Hampshire, and she actually became well known after Washington's death and after Martha had freed all of her other slaves, and she felt she was no longer in danger of being captured and dragged back into slavery. She had married and had several children, but she really did have a hard life and lived in poverty. A reporter asked her near the end of her life if she ever regretted leaving the relatively comfortable life she had with the Washingtons, given that her life of freedom was much more hard work and poverty than she had ever experienced as a slave. Her response was clear and unequivocal. "No, I am free, and have, I trust, been made a child of God by the means. For Ona, like most Americans, freedom was more important than comfort. My book recommendation this week is Slavery and the Founders by Paul Finkelman. This book looks at how the founders struggled with the growing paradox on permitting slavery in a society that was based on individual freedom. It begins with the Constitutional Convention and mostly follows Thomas Jefferson's path in wrestling with slavery over the course of his life. The author is a college professor who's written quite a few books about the history of slavery and who's taught at a bunch of colleges and universities around the U.S. If you want to give it a try, it's called Slavery and the Founders by Paul Finkelman. My online recommendation is a journal article, which is also written by the same author, Paul Finkelman. It's called The Kidnapping of John Davis and the Adoption of the Fugitive Slave Law of 1793. This article is a detailed look at the story of the man whose failed struggle for freedom provided the motivation to pass the Fugitive Slave Law. Now, I can only find this article on JSTOR. You do have to register to access it, but registration is free. As always, I've included direct links on my blog and in the show notes. My question this week asks, would Britain have still colonized Australia even if they won the American Revolutionary War, since they knew about Australia's existence before the war even happened? Now, that's an interesting question, and of course, any alternative history is fraught with all sorts of subtleties that could change the way it goes, so you got to take any answer with a grain of salt. That said, I think the answer would be yes. Britain probably would have colonized Australia even if they had held on to all of their colonies in North America. Its existence was known to Europeans for nearly 2 centuries before the Revolution, but British interest really got going after James Cook reported on his explorations in 1770. American independence might have spurred activity since Britain needed a new place to move its convicts, but American colonies had already been getting problematic for that purpose. As colonial society became more well-established in North America, the colonies were pushing back on being a dumping ground for convicts. Also, even before the Revolution began, Britain was getting concerned that North America was becoming too heavily populated to control. Britain was at the peak of its colonization during this era. They were looking to establish colonies in Africa, Asia, even exploring some inroads in South America. Australia seemed to have a good suitability for agriculture and did not have a large native population that seemed capable of putting up serious resistance. Britain established its first permanent colony at New South Wales in 1788. This was during the same period that Britain was still trying to conquer and control India. Now, if Britain had to devote a great deal more resources toward holding North America, it might not have been as aggressive in establishing the other colonies, but if North American colonies had remained easy to run, as they had been up until the 1760s, Britain only had greater incentive to establish more profitable colonies wherever else in the world that they could. What's perhaps less clear is whether Australia would have remained entirely under British control. Had the French Revolution, which I assert is a direct result of the American Revolution, had not put France's focus more on Europe, the French might have begun to colonize Australia as well. This would have led to a partitioned continent, much like we saw for many years in India. If you have a question you'd like me to answer, please reach out to me, either via email or on X, Facebook, Quora, or Reddit. Well, that's all for this week. I hope you will join me again next week for another American Revolution podcast.